She has to prove that Mr. Waldman's statements are false in their essential meaning. In other words, she has to prove that her abuse claims are not a hoax. But as we've seen, the evidence is overwhelming that Ms. Heard's claims of abuse are false. We should also spend a bit of time talking about actual malice. It is Ms. Heard's burden to prove that Mr. Waldman's statements were made with actual malice. And actual malice means knowledge that the statements were false or reckless, and that's an important word, reckless disregard for the truth. But here, there is clear evidence that Mr. Waldman genuinely believed that Ms. Heard had committed a hoax. You watched him give the testimony by deposition in this case. He testified about the evidence he found persuasive, the numerous witnesses and the sworn depositions of the police officers who went to the penthouses that night and again saw no injuries. There is no evidence in this record, none, that Mr. Waldman acted with actual malice. He believed Mr. Depp. He believed the record. It's also important to understand that because Mr. Waldman's statements were not made by Mr. Depp, Ms. Heard needs to prove that Mr. Waldman was acting as Mr. Depp's agent. And within the scope of that agency, within the scope of the agency of the employment, when he made the statements, Mr. Waldman is a lawyer. Ms. Heard has not presented evidence that making those statements was part of Mr. Waldman's responsibilities as Mr. Depp's lawyer. There's nothing in the record. Ms. Heard is also claiming to be suffering from PTSD and claims that she has something to do with Mr. Waldman's statements. Ms. Heard wants you to believe that she suffers from PTSD because Mr. Depp purportedly abused her. But as usual, Ms. Heard is not telling the truth. As you heard from Dr. Shannon Curry, Ms. Heard does not have PTSD, and she does not act like a person with PTSD. Ms. Heard is an actress in a major film, involved in sommelier training. She just had a baby. Dr. Curry also found that Ms. Heard attempted to grossly exaggerate her symptoms during testing, which is a sign of malingering, or said differently, of Ms. Heard lying. Ms. Heard hired Dr. Don Hughes to help her with this narrative. Dr. Hughes did not catch Ms. Heard's exaggeration during testing because Dr. Hughes used an improper malingering screen test. She wasn't going to find it. One that is meant to identify an examinee's attempt to fake a severe mental illness or psychosis, not PTSD. Dr. Hughes diagnosed Ms. Heard with PTSD without administering the gold standard diagnostic test used for PTSD. She diagnosed her, think about that, she diagnosed her with PTSD before administering the test she admitted was the gold standard. 2 years after diagnosing Ms. Heard with PTSD, and curiously, shortly after Dr. Curry administered the gold standard diagnostic test in her evaluation of Ms. Heard, but before it was disclosed, Dr. Hughes decided to administer the gold standard, finally. Nevertheless, even after Dr. Hughes used the proper test, there were a number of deficiencies in her administration of that test. You saw them, including her failure to even follow the instructions that render her diagnoses unreliable. Ms. Heard's claim for monetary damages related to Mr. Waldman's statements, frankly, it's a fantasy. Ms. Heard speculates wildly that she has somehow been damaged by Mr. Waldman's statements. But in reality, Ms. Heard has not shown any damage at all that was because of or by Mr. Waldman's statements. There is evidence of a mountain of negative press coverage about Ms. Heard, including press reports about her defecating in Mr. Depp's bed, cutting off his finger, and putting out a cigarette on his face. But none of that has anything to do with Mr. Waldman's statements. And Ms. Heard has presented no evidence, none, of any film or other project that she has lost because of the statements. In fact, you heard from Warner Brothers president, Walter Hamada, who explained that Ms. Heard suffered no loss, none. No loss of compensation or other adverse effect on her major film, Aquaman 2. You heard it straight from him. Ms. Heard's expert, Catherine Arnold, testified, but for the statements from Mr. Waldman, Ms. Heard would be much more successful in her career. To form this opinion, Ms. Arnold compares Ms. Heard to actors such as Jason Momoa, the actual Aquaman, Chris Pine, Gal Gadot, and Zendaya. But as Richard Marx, who does deals every day, that's his job, not testifying here for a paycheck, does deals in Hollywood, and Doug Banya both testified that these actors are simply not comparable to Ms. Heard. After all, Jason Momoa, he was Aquaman. Chris Pine, he was Captain Kirk. Gal Gadot, Wonder Woman. Zendaya, she's been acting since she was 13 years old on the Disney Channel. And she's in every single Spider-Man movie. Further, the Q scores of these actors are not at all comparable with Ms. Heard's Q scores. As Mr. Banya testified, Ms. Heard's rating was less compared to these actors, and all of Ms. Heard's Q scores ratings were less favorable than the average of all performers. As you heard from Michael Spindler, because Ms. Arnold relies on the salaries of these comparable actors to calculate Ms. Heard's damages, Ms. Heard's claim for damages makes no sense. There's no connection. Further, and more fatally for Ms. Heard's damages claim, is that there's no connection to the Waldman statements, to Mr. Waldman's statements. Even if you find damage to her career, you have to connect it to the defamatory statements. There is no connection. Mr. Banya testified that all the negative tweets that Ms. Heard has entered into evidence have no causal connection to the statements underlying Ms. Heard's counterclaims. Specifically, Ms. Heard's expert, Mr. Ron Schell, presented a flawed methodology that included picking out hashtags at random, including Justice for Johnny Depp. What does that have to do with the Waldman statements? And counting accompanying tweets, even though it had nothing to do with Mr. Waldman. Ms. Heard's counterclaim is based on statements by Mr. Waldman, not Mr. Depp. Ms. Heard knows perfectly well that she hasn't suffered any damages from those statements, buried at the bottom of articles in a mere tabloid, the Daily Mail. And the statements are substantially true, since all they do really is point out that Ms. Heard's abuse allegations are false. Ms. Heard's counsel argued that Ms. Heard did not write the title of the online version of the op-ed, which stated, "I spoke up against sexual violence and faced our culture's wrath. That has to change." It does not matter whether or not Ms. Heard wrote the title. You will recall from the court's instructions this morning that what matters is whether Ms. Heard republished the defamatory language. That instruction states in part that you should find Ms. Heard republished this article if she, quote, retransmitted the defamatory material with the goal of achieving a new audience. Stated differently, republication occurs when the speaker has affirmatively, that's important, affirmatively reiterated the statement. Ms. Heard affirmatively reiterated the statement. She posted it on her Twitter. If we could please pull up Plaintiff's Exhibit 3. This is the tweet Ms. Heard sent. She retweeted the Washington Post tweet to a new audience, her own Twitter followers. And she affirmatively reiterated the statement by proudly declaring, "Today I published this op-ed in the Washington Post." She didn't quibble with the title. She said proudly, "Today I published this op-ed in the Washington Post." The title of the op-ed was prominently displayed in the tweet. That is enough for you, members of the jury, to find that Ms. Heard republished the title of the op-ed and adopted the statement as her own. She can and should be held liable and responsible for that statement. Ms. Heard tries to make something out of the fact that Mr. Waldman reported her to law enforcement in Los Angeles for perjury after her allegations of abuse were made against Mr. Depp. But I'll submit to you that all this proves is that Mr. Waldman believes Ms. Heard has committed perjury. Mr. Ronborn argued that the lack of supporting evidence for Ms. Heard's allegations of horrendous, constant abuse is somehow not something to be considered, that it is shameful for you to consider the fact that she didn't document all the terrible injuries that she claims to have suffered. That is a twisted argument. First, you know, because you have seen and listened to Ms. Heard in action, that Ms. Heard is a woman who's documenting things throughout their relationship. And it is instructive that the things she chose to document had nothing to do with violence. She documented Mr. Depp sleeping. She documented lines of cocaine, featuring prominently Mr. Depp's loan-out company or production company, Infinitum. Stage photographs. That's what she documented. Mr. Rottenborn's entire argument assumes that Mr. Depp, a man, should be disbelieved because despite the fact that Ms. Heard can't support her accusations with actual evidence. What we have put to you, the jury, is not that because Ms. Heard didn't take enough pictures or tell people about abuse that it didn't happen. What we have put to you is that given how brutal and constant the abuse Ms. Heard claims, she would have had serious injuries. That's a fact. She would have had serious injuries that would have been observable in the pictures we looked at and by the witnesses we heard from, and would have required medical attention. That's it. Ms. Heard testifies to injuries that multiple people didn't see.